All right, good evening, everyone. Welcome to the inaugural Honors Program Student Scholarship presentation. If everyone could mute your mics and make sure that they stay muted unless you're speaking, and then enable the chat function so that on the right side of your screen, you're able to communicate with our scholars. But let me just tell you as we start this that tonight has been in the works for nearly a decade. That is, about a decade ago, we started to envision what an honors program would look like. And so I'm so glad that this night is finally here. And more importantly, I'm so glad that you're here. Well, as we envisioned an honors program, we built it and we're building it around 5 pillars: recruitment, enhanced student experience, placement, a brand of gratitude, service, and academic excellence, and development. And for 2 years now, the honors program has hosted monthly events, and those monthly events have included deans and professors and judges and general counsel and practicing lawyers. The topics have been everything from judicial clerkships to the financial crisis of 2008. How timely was that? Christian worldview discussions, you name it, we've talked about it. But this is the signature event. This is why we have an honors program, to showcase our students, to showcase their commitment, to showcase their commitment to academic excellence, to showcase their scholarship. And so that's why we're here tonight, and we're so excited to be here. On January 3rd of this year, the three 3L students that are going to present tonight, the 3 of them and I started to plan an in-person live event. And for a couple months, we planned that. We had the date, we had the format, we had the room. We were going to have snacks and the like. We were going to have a reception. It was going to be great. And then the world changed just a little bit. And I cannot tell you how thrilled I was when I reached out to the 3 student scholars and I asked them, all right, what do you think? You were going to be our inaugural group of students to do this. It's changed a lot. Would you be willing to come online and, despite the difficulties and the challenges, still do it through this medium? And without a doubt, without hesitation, each one of them said yes, which underscores their commitment to service, their commitment to academic excellence, and their commitment to building this program. And so the schedule that I sent to you is the schedule we will hopefully follow tonight, but be a little bit flexible. We'll see how the technology works. We'll see how everything goes. But we do intend to follow that. Each student will get 15 minutes to present. During the student's presentation, if you have questions about the article that you read or how the student picked that article, anything that you might have, feel free to use the chat function on the right side of your screen. None of the students will answer any questions, however, until the final 15 minutes of tonight's program. So each one will have 15 uninterrupted minutes to make their presentation. And we'll just go 1, 2, and 3, and then collectively they will answer your questions. I also want you to encourage them. I want you to encourage them early and often. So feel free to send chats to them in real time. At the end of the event, normally what would happen is the 3 of them would be in the front of the room, and then most people would come up to them and continue the conversation, perhaps have additional questions, or just give hugs or high fives to congratulate them. In this environment, there's probably no hugs. It's against the law probably anyway. And so we still want you to engage them. And there's 2 ways you can do that at the end of the evening. One, use the chat function. Just use the chat function to tell them how much you were impressed by them, how thankful you are for them, or just come into this medium, start speaking, and the software will pick up your voice, bring your face to the front, and you can have that interaction. All 3 of them have agreed to stick around a little bit beyond the 7:15 time to engage with you. And so with that, Dean Faulkner, if you could say a few words of encouragement and pray over this evening, that would be great.
Can you hear me, Professor Lucas?
Loudly and clearly.
Perfect. Thank you. I appreciate it. I just want to follow up with what Professor Lucas just said, and that is this. We have been trying to build together with Professor Lucas, with the honors program, with our law review, and with several other mechanisms throughout our school, a culture of intellectual curiosity. And this culture of intellectual curiosity is really anchored in not only what the faculty does, but what the students do every day. And I just can't thank these students enough for taking this time when they are in the middle of preparing for exams and trying to finish up an abbreviated and an unusual schedule to take time out and present these papers in this less than normal format. But whatever the format, I can tell you that the law school is proud of each and every one of you who have participated in this, who are doing this tonight in our honors program, in our law review, in our entire student body. And I really want to lift up Professor Lucas for his work with the honors program, with Dean Todd, with his continued efforts to push our faculty with additional scholarship, and just our entire community. But these three women that are going to be speaking tonight are definitely some of the leaders of the pack in our school. So kudos to you for doing all that you do for us. And with that, if you don't mind, I will say a prayer and we will get started. So please pray with me. Heavenly Father, we thank you for this night. We thank you for the energy and the excitement that it brings. We thank you for the dedication of our students as they continue to try to not only build their own intellectual curiosity and answer that curiosity, but also to be further contributing to the greater conversation at Liberty Law School and beyond. Lord, we know that the spring brings renewal and Easter brings renewal through the resurrection of your Son, our Christ. But Lord, also this is going to bring a renewal and revival. This first event here is going to bring that renewal and revival for our community, and hopefully encourage the numerous students out there listening to engage and follow in the footsteps of Hannah, Anna, and Jillian. And Lord, we just thank you for that. And Lord, we just thank you for the opportunity to learn together and to love together and to serve in this community that is Liberty Law School. Be with them, give them courage, give them wisdom, give them strength, and give them the tenacity to present great presentations tonight and answer some very thoughtful questions from our body. With all this, we give you the praise and everything and the glory in the name of your Son, Jesus, our Christ. Amen.
All right, thanks, Dean Faulkner. Well, it's my privilege then to start the introductions of our students. After I finish speaking, I will post their bios in the chat function. If you didn't get a chance to read the bios in the emails that I had sent out or in the scheduling invite, but I will post those bios. I won't repeat those here, but let me just kind of go through each one so you get a little sense about who our third-year students are in the honors program. Up first is Christiana Hope Johnson. And what I like about her name is the first 5 letters of her first name really signify her purpose in life and who she follows. And it's just right there in her first name. The second, her middle name is Hope. And ever since I met her, she has had this hope and this faith that she will follow her creator to do everything she possibly can to serve others. And you can kind of see that in how she challenges folks in law review. She's the editor-in-chief of our law review. And if you look at the topic tonight, if you had a chance to read her article, it's not a get out of jail free card, prosecuting international sex crimes when the victim does not testify. And so in a few moments, I'll have her come forward and start her presentation, but I'm absolutely thrilled that she's going to kick us off and be the first person to present. The second presenter is Hannah Joy Coad. And Hannah, you have been so enthusiastic for every single honors program event. So every month I plan an event and then host an event. And the first person who will always respond with lots of exclamation points and lots of excitement is Hannah. And so your middle name also is a perfect fit because you bring me joy each time we get to do an event together. And then it's almost like clockwork that after the event, I will get at least one handwritten thank you note, and it always comes from you. And so I appreciate you and everything you've given to Liberty and to the honors program. And I look forward to your presentation in a little bit as well. And then finally, Jillian Engen will be our, and Hannah's topic will be the degree of alteration necessary for patent eligibility of synthetically printed DNA post-Myriad genetics. And so I've practiced that for about 3 days just to be able to say that, and hopefully it came across loudly and clearly. But that's what Hannah will be presenting. And then finally, the final 15 minutes of the presentation portion of the night will be our third-year student, Jillian Engen. And what I have to tell you about Jillian is a few years ago, so the honors program has been in the works for years, almost a decade. And about 2.5 years ago, we kind of did a light, soft launch, if you will, kind of like a soft restaurant opening. And Jillian was part of that initial night. And so I brought together a group of students. Dean Faulkner, Dean Todd came to that meeting. We served pizza. We brainstormed about what my vision was, and then what their vision was, what the students thought we could do together. And of course, that night, this was a signature event. You just have to wait for these things to happen. But Jillian was there. She was there from the first moment of the program, and she's, without missing a beat, she was happy to participate even when we changed this format. The last thing I'll say before we bring up Anna is this is the inaugural event for this. But if we do our duty, 40 years from now, they will not be here tonight on the inaugural honors program student scholarship presentation. They will be doing the 40th annual honors program student scholarship presentation. And I can only imagine the amount of participants and the number of students and the vast array of topics that our students will have worked through. I can't imagine in the next 4 decades where everyone's going to go. Just think about where Anna and Hannah and Jillian alone are going to go. And then our second-year students next year will be doing their presentations. So with that 15 minutes of introduction, I think we're still on schedule. And so Anna, if you are ready, the floor is yours.
Okay, can everyone hear and see me? Great, I got a thumbs up from Professor Lucas. I think I'm ready to go. Like Professor Lucas said, I wrote my article on international sex crimes and prosecuting them when the victim is unable or unwilling or unavailable to testify. But instead of just going through my article, I encourage you to read it, especially during this time of quarantine, when you may have some more extra time on your hands to read a 36-page article. But I want to start just by giving you my reasons behind the article and where I got the idea from. So my interest in international sex crimes, which is pretty random to some, started in high school when I started hearing more about this issue of international sex trafficking. And through high school and undergrad, I worked with different nonprofits and had a lot of conversations about it and read about it. And it just kind of had this pull for me that I couldn't really explain, but just an interest in advocating for these victims. And in undergrad, I went to Cambodia, actually, and I met some girls who had been trafficked. We visited a safe house and we interacted with them, and it changed my life to be able to meet them and to talk with them and just to see the hope and the joy that they found in spite of the just horrific crime that they had suffered. On that trip, our translator talked to us more about the culture of Cambodia and the history of Cambodia. Now, after the Khmer Rouge regime, there was a surge in sex tourism, where people from different countries traveled to Cambodia and took advantage of the fact that after many men had been killed, not just men, but women and children as well. But after the Khmer Rouge regime, there were many vulnerable women and children that were left that could be easily preyed upon. And so there was a surge in sex tourism that happened. And that just interested me as far as that didn't just happen back then, right? We know that sex crimes are rampant today and that people are vulnerable today, especially children. And so when I went to law school, right, I have that in the back of my head as far as I want to do something to help victims of these heinous crimes. I want to learn more about this, and I want to learn more about how the law intersects with this. So with that, I eventually get onto law review, obviously, and I try to figure out what I'm going to write on. And to be honest, trying to figure out what to write a 30-page article on, working on it for 2 years is a little bit intimidating. So I knew that I wanted to write about something I'm passionate about, something I'm interested in. So obviously, right, I wanted to write something about international sex crimes, something about maybe children. And so I went and talked to my professor Jillianne, and he gave me the idea that the article is based upon. What happens in a situation in which you have an international sex crime that's occurred against a child, and that victim is not going to be able to testify in a United States court for whatever reason. They're not willing to come over. They don't want to be in front of an international or different countries' tribunal. They're not able. You can't find them, but you have statements from them. How can you prosecute that crime? Can you prosecute that crime? And that's why my article is entitled "It's Not a Get Out of Free Jail Card," because I don't think it's right for United States citizens to go overseas and commit the acts that I'd heard about that happened in Cambodia, but that we know still happen today and quite often. I don't think it's right for them to go to a different country, commit those crimes against children, and then get away with it because it's more difficult to prosecute them, because you have more issues with evidence. You have more issues with getting their statements and things like that. So trying to brainstorm a solution to that. So in my article, I start out with a case, which I kind of frame my article around the United States versus Durham. And it gives an example of how these types of cases tend to pan out. But it actually is a best case scenario, in my opinion. In United States versus Durham, a missionary goes over to Kenya, Africa, and is staying in a home with many other girls who are orphans, staying in this orphanage. And one day, Miss Wambugo, the manager or supervisor of this orphanage, walks in, and she sees that Mr. Durham is laying in a bed with one of these girls. Obviously, this isn't right. This is suspicious. Something's going on. So she has a conversation with the girls, and the girls tell her that they've been doing bad manners with Mr. Durham. Those are the words that they describe what he had been doing to them. Eventually, Mr. Durham, after denying it, admits to raping and molesting these girls, committing heinous crimes against them for months with no one knowing. Eventually, he gives a statement to Miss Wambugo and then heads back to Oklahoma, where he's from. But he is indicted, he is prosecuted, and in the trial, 5 of the 8 victims testify. He's convicted and sentenced to jail. But that, to me, is a best case scenario in one of these cases, because the victims were able to testify. They were able to give that compelling testimony as to what happened to them, what he did to them. So then the question, right, arises again, what happens when that's not the case? What happens when the little girls aren't able to come to the United States and testify? Does that mean that people like Mr. Durham just get away with it? I think the answer should be no. And so that's why I wrote my article on what I did, trying to just explore ways that prosecutors could use current hearsay exceptions and then eventually proposing a new hearsay exception so that perpetrators are held accountable and so that victims attain some sort of justice. So first in my article, I won't go through everything, but I'd like to give a short summary, go through different hearsay exceptions that currently exist. So I cover some under 801, 803, 804, and 807, and I use current case law to just give examples of how prosecutors could use arguments that have been used previously in cases involving international sex crimes against kids. And a lot of those cases that I reference aren't necessarily international crimes, or not even all crimes against children, but I think that they help give a sort of practical aspect of how these arguments could play out in real courts. And I also use them as a jumping off point for proposing new creative ways to use them. So for instance, in one case, one man goes overseas quite often to to have sex with little boys, and he uses a man in somewhere, I can't remember now, but somewhere in Eastern Europe. He uses kind of a middleman to set up these meetings, to find these boys, to set these meetings up. And so in the actual court case, the relationship between this man and his middleman is referenced as a conspiracy, but the prosecutor doesn't use the co-conspirator exception. They're able to use a different hearsay exception. But that's just an example of how I use a current case to propose new creative ways. So if the hearsay exception used in that case wasn't an option, could prosecutors use a co-conspiracy element? Could they use that exception under 801 to admit statements? If someone's using a middleman overseas to set up these meetings, could that be used? So my article is really just trying to provide a launching off point for more discussion. So it looks at current case law and then kind of asks questions as far as areas to explore in the law. Essentially trying to just make the point that once a perpetrator leaves the U.S. borders, they shouldn't be given a card that they just get out of jail, that they can just go and commit these heinous crimes. But that there are current ways in which prosecutors can use hearsay exceptions to get those statements in. I don't just talk about hearsay issues, of course. Then there's confrontation clause issues that arise, because justice, for one, isn't necessarily justice. We also need to keep in mind the defendant's rights. And so the confrontation clause is important to analyze and look at. I look at the policies, and I land pretty heavily on Ohio versus Clark, because it addresses the primary purpose behind statements and determining that primary purpose, determining when a statement is testimonial. Because as we know, if a statement isn't testimonial, then the confrontation clause isn't going to be an issue with that specific statement. In Ohio versus Clark, the court found that the primary purpose was safety and it wasn't prosecution. And so the statement made by a young child to his teacher regarding abuse was admissible. I think that it is very applicable in a lot of cases in which a young child or a child is telling someone about abuse they've suffered in an international sex crime case, because in a lot of those situations, I think the primary purpose is not necessarily going to be, sometime down the road, this person should get prosecuted, but more so safety of the child. And after talking about, current hearsay case law in my article and the confrontation clause, I talk about applying all of that to a hypothetical scenario in which we have the same facts of United States versus Durham, but what happens if those victims weren't able to testify? So try to apply different hearsay exceptions to that sort of scenario, confrontation clause analysis, and kind of exhausting all the avenues that I think currently exist, with the ultimate conclusion. I think that currently there's pretty good there's a pretty good variety of options for prosecutors to be able to get these types of statements in, but there's still going to be situations in which current hearsay exceptions don't provide an avenue. So what happens then? So in the article, and I'll just speak briefly upon it, but trying to come up with a new hearsay exception for those types of scenarios. And essentially, it's a glorified residual exception. It takes a tender years exception from New Jersey that applies just to sex crimes against kids under 12. And I expand it to sex crimes against children that happen internationally. And I tweak it, and I add some more factors to try to ensure the reliability of the statement. But I propose that adding this exception could provide another tool for prosecutors to prosecute these crimes, but it also would ensure that justice is also preserved for the defendant, because it mandates that the statements aren't testimonial, or they apply, or the forfeiture exception applies under the confrontation clause. That's how I end the article. And to be honest, in writing the exception and tweaking it, I was a little nervous because I think whenever you propose a new law, it can be kind of intimidating because current legislators are, very versed in this area. But I talked to Professor Lucas about it, and he gave me some very wise advice, I think, which is that when you write a law review article, it's not necessarily about getting a right answer or providing the best solution, but it's about kind of fueling the fire for discussion and debate. And so that's my heart behind this article. That's my purpose behind it, is that it just asks questions and it gets some more discussion going. Because I really am a firm believer that, especially in this area of the law, with children being violated, that awareness is so key to protect children and to help stop this. And so even if it just helps more discussion in this area, people brainstorming and coming up with better ideas than I did in my article, it will have been worth it, because hopefully it will protect more children. And ultimately, that's what I believe is, especially as Christ followers, that we should be on the forefront of our mission and our goal. So with that, I'll pass it off back to Professor Lucas, but I just want to thank him for giving me this opportunity to present and share my heart and my passion for this area. And thank you all for coming and listening. And I will try my best to answer any questions that you have.
Wow. That's all I can say is really wow. Anna, that was outstanding. I'm so proud of your passion and the purpose that you have in your life. Let's open the chat function. I just muted everyone, but let's use the chat function for two reasons. One, to let Anna know how amazing that was and how proud you are of her for being the first one to have ever done this at Liberty Law. And so the inaugural honors program student scholarship presentation is off and running, and it couldn't have gotten off to a better start. So on the call right now, you might be wondering, you might be kind of scrolling through the guest list on the right side of your screen, and you'll see that the administration and the faculty of this law school are here. It's been a rough couple of weeks, and these folks have worked tirelessly to try to figure out the best way that we can love our students by continuing to present and provide the absolute best education possible. And so I'm so thankful that they're on the call, and I'm so thankful that they're committed every day to our students. There are also honors program students on the call. That is first-year law students and second-year law students. You kind of see the expectation for you. Next year, the 2L students will have this opportunity, whether it's on this medium or back to the traditional way of doing it in person. But get ready, do your best, because you too will follow in the footsteps of these students. There's a special guest from Iowa. If that special guest from Iowa would unmute and start speaking to us, you can now say a few words.
Professor Lucas, I'm honored that you gave me this opportunity to listen in and on an outstanding presentation. And I loved reading your article today. We're up against an opinion deadline in Iowa, but I made time to read it, shared it with other members of the court. And your passion is needed out here. There are bad manners in Iowa too. I could have used you a few years ago when on a 4-3 opinion. I was on the losing side in a dissent where the domestic abuse victim changed her story under pressure from her boyfriend, and I advocated for a categorical rule to allow her identification of her abuser in the ER to come into evidence. We lost that battle. With your help, maybe we'll win it next time. Your article is an excellent roadmap for going forward. And by happy coincidence or God's grace, I've been tasked with chairing an effort to update and review the Iowa Rules of Evidence. I'd like to involve you in that next year when you're working for me. And that will be your opportunity to team up with a great group of judges and lawyers and perhaps get your proposed new hearsay rule onto the books in Iowa as another model for other states to follow. Professor, thanks for letting me jump in. Anna, great job. Thank you.
Well, ladies and gentlemen, that is Justice Tom Waterman from the Iowa Supreme Court. And a number of years ago, just to show how relationships matter, we reached out to his colleague, Justice Ed Mansfeld, and asked him to come to judge a moot court competition, and he did. And he fell in love with liberty law and the spirit of liberty and the students. And so we asked him, we said, now, do you have any colleagues, do you think, who would want to make this trip out here and follow in your footsteps? And Tom Waterman jumped at the opportunity. Literally, he jumped. He got airborne. He was so excited. And literally within minutes of being on our campus and getting to know our students, Justice Waterman was asking, how can I help? How can I help what you're doing out here? It is so special. And so we went to a nice dinner with some honors program students. He met Anna that night and instantly knew that he had found a future clerk. We never knew, of course, that it would end up with a presentation like this or that he would be a special guest, but relationships matter, and I think that's the spirit of liberty. So Justice Waterman, we're so proud and privileged and thankful for you and your colleagues, and we're so thankful that you came tonight. And by the way, he's in my hometown of Pleasant Valley, Iowa. He lives about 3 miles from where I grew up, so that's another connection. All right, there are other special guests. Everyone here tonight, of course, is a special guest. I think anytime you have an inaugural event, it's special, and anyone who supports that is special, and there will be a legacy for sure. But there are some honors program mentors on the phone call tonight. I'm counting 3 of them: Caitlin Martin, Andrew Connors, and Stephen Scherer. As we built out the honors program, we thought that it was important to create this connection from the time we recruit students into liberty law all the way through their experience here into their placement, the branding that runs through them, and then as they give back and develop this program. So we've built on those 5 pillars I talked about earlier. And so we've created a mentorship program where alumni will mentor our 2nd and 3rd years. Our 2nd and 3rd years mentor our 1st years, and we will continue to build that out. And Caitlin Martin is the class of 2016. She was editor-in-chief, as most of you know, just like Anna is. She works at the PLDR law firm here in Lynchburg, and she and her husband, Zach, are online, and we're thankful for you. Andrew Connors is also on the line. He's an honors program mentor. And he actually is and Caitlin, by the way, is a mentor to Anna Johnson and to Jillianne Engen. And Andrew Connors is a mentor to our next speaker, and that is Hannah Coad. Hannah, you have the next 15 minutes.
Thank you. Can you hear me?
Absolutely, loudly and clearly.
Excellent. Okay, just one moment here. All right, can you see my presentation there?
Perfect.
Excellent. Okay, so let's get started on the presentation. My note was on the degree of alteration necessary for patent eligibility of synthetically printed DNA post-Myriad genetics. So our future includes synthetically printed DNA, and this is an exciting thing, but it's also something that comes with a lot of risks and ethical implications as well. I got interested in this topic when I was interning at the House Judiciary Committee. I was an intern for the subcommittee on courts, intellectual property, and the internet. And I realized there was a lot of unclarity in this particular area, which got me intrigued to write this note. So biotech companies are now printing and selling synthetically printed DNA. This synthetically printed DNA allows researchers quick access to custom-made DNA strands. Companies and universities such as UC Berkeley and Lawrence Berkeley National Laboratory have invented a new way to synthesize DNA that is more accurate and faster than previous methods, which is really exciting. The Center of Excellence for Engineering Biology has gained global support for the Human Genome Project Right. That's GP Right. GP Right is an international research project led by a multidisciplinary group of scientists and researchers who work on genome-skilled engineering as well as transformative medical applications. GP Right Consortium boasts that there are nearly 200 scientists affiliated with more than 100 institutions or companies in 15 countries who have expressed interest in participating in GP Right. The goal of this consortium is to recreate the human genome, and they can do this now through 3D printing. Here is a picture of the DNA synthesis machine for high fidelity DNA printing at UC Berkeley. It takes a lot of different chemicals, and it takes all the different components to put this DNA together. I found this topic especially interesting too, because during my undergraduate in biochemistry at Grove City College, I did gene research, and then I also spent a summer at a laboratory that did hepatitis B cancer research on woodchucks. And so this topic was very fascinating to me and my background. So the main topic and question that my note tries to address is this. To what extent must DNA be altered through intron and extron splicing or through adding or deleting nucleotide sequences to render the strand patent eligible? That requires a little bio lesson that's coming up. So the flow of the argument is I evaluated the background on patentable subject matter in relation to biological systems, and then evaluated the likelihood of patentability under the three main Supreme Court cases, which are Myriad, Mayo, and the Alice framework. Then I looked at how synthetically printed DNA would fit under this if you removed introns and from the extrons. And then also I evaluated the need for statutory clarification for synthetically created DNA. So here's a DNA strand, and you can see that there are four main components that make up the genetic code, and they're bound together by hydrogen bonds, and then they form this double helix. Here you see a DNA strand that has extrons and introns. The extrons are the coding sequences versus the introns are called junk DNA. So the issue is, what if you were to remove the introns and then you have the spliced mRNA, and you are able to genetically patent this coding DNA. Here is a simplified version of what a number of laboratories try to do when they create new DNA strands to express certain genes that were otherwise not naturally expressed. So patentability of live organisms is addressed under 35 U.S.C. Section 101. It addresses that a composition of matter could be patent eligible. And in Diamond versus Chabarki, the Supreme Court held that live man-made microorganisms are patentable under Section 101. So let's look at Myriad and the patentability of cDNA. Now, cDNA is not exactly DNA itself, it's synthetic DNA. So in Association for Molecular Pathology versus Myriad Genetics Incorporated, Myriad Genetics obtained several patents on the discovery of the location of BRCA1 and BRCA2 cancer-causing sequences in genes. The court held naturally occurring DNA segments that are products of nature are not patent eligible under Section 101. But Justice Scalia stated that cDNA is a synthetic creation not normally present in nature. This was very significant because this opens the door for patenting synthetically created DNA. Mayo's combination of abstract ideas. In Mayo, Collaborative Services versus Prometheus Laboratories, the Supreme Court evaluated patent eligibility of a method for determining the proper dosage of certain drugs. The court ruled that laws of nature and natural phenomena and abstract ideas are not patent eligible. The third Supreme Court case that really changed patentability was Alice and the two-part framework. A number of courts have used this two-part framework for analyzing patentability, from computer systems to algorithms, to microorganisms, to chemicals, to even business processes. And the first step is for the court to decide if the subject matter at issue is directed to a patent ineligible concept. So they would look under 35 U.S.C. 101 for that. And if so, the second step is for the court to determine whether the claim's elements taken in combination form something new and transform the nature of the claim into a patent-eligible application. So maybe the elements themselves are not patent eligible, but what if you were to combine the two elements? Does that make something new? Does it make it something creative? And that's really important for DNA sequencing, because maybe the independent chains of DNA are not patent eligible, but if you were to combine them in a certain manner, then maybe you're making something new, and that would be transformative under this test. So my note evaluates a number of district and circuit court analyses after Myriad genetics. So let's just go through a few of the rule statements that are the main takeaways. So in the first one, methods such as PCR, that's polymerase chain reaction, to amplify certain strands of this CFF DNA, which are well understood routine and conventional activities, are not patent eligible. So here you see that PCR is just a normal procedure in a laboratory. It amplifies DNA. That procedure itself is not patent eligible. And then not all synthetic DNA is patent eligible. Oh, there we see that some synthetic DNA may be patent eligible, but some may not. So this is undigging some unclarity that needs to be clarified. And then synthetic DNA primers and methods for analyzing BCR-A1 and BCR2 sequences are not patent eligible. So it's important to know that these primers are little tiny DNA strands that you use in PCR. It gets the PCR reaction going. So in my undergraduate, when I was doing DNA sequencing, we did PCR. That was the main thing that we did. And we put these little primers in with the different components of DNA, and it got the reaction going. And the little primers are the complementary strand of a DNA so that the strand can start to form. So it's understandable that these primers wouldn't be patent eligible. And then innovative and transformative steps are key in gene method patents. So there needs to be this innovation, this transformative nature. So then in Ray Roslin Institute, that was the Dolly the sheep case. And that was a big case because Dolly the sheep was cloned. That was actually in my home state, Idaho. And there are now two little sheep that have the exact same DNA. But you see, the court said that Dolly the sheep could not be patented because she was a direct replica of her mother, the donor sheep. But the court stated, to be clear, having the same nuclear DNA as the donor mammal may not necessarily result in patent ineligibility in every case. This opens a huge door, because what that means is you could have an exact replica of something naturally occurring, but the process to make it was not naturally occurring. And because it's a replica, does not necessarily make it patent ineligible. That's a very significant breakthrough there. And then even groundbreaking discoveries can be deemed non-patentable if they arise from a newly discovered natural phenomena combined with only routine and conventional steps. Once again, it must be transformative. Something new must come from it. My paper and my note largely focuses on this need for steps statutory clarification for synthetically created DNA. There are nearly 30,000 human genes that are patented in the United States. These are itsy bits of who we are as individuals, and people own the rights to license this out. An important distinction must be made that DNA sequences or genes may be patented, while the human genome currently may not be patented, which is understandable. But the question is left open of whether it could be patented if those introns, if you remember, were removed. The European Union has codified a rejection of the Products in Nature doctrine in the Biotechnology Directive, so certain countries are trying to address this issue as they get ready for more scientific advancements. And then altering genes of one species with sequences of another is just common practice. So this is nothing new to alter the genes, but it is new that now we can 3D print them. I want to read you this quote from Lee Silver, and he wrote this article as stating this quote, and this quote is from Remaking Eden, How Genetic Engineering and Cloning Will Transform the American Family. This is what he said. In the short term, most genetic enhancements will surely be much more mundane. They will provide little fixes to all of the naturally occurring genetic defects that shorten the lives of so many people. They will enrich physical and cognitive attributes in small ways. And as the years go by, over the next 2 centuries, the number and variety of possible genetic extensions to the basic human genome will rise exponentially. Extensions that were once unimaginable will become indispensable to those parents who are able to afford them. So there are a lot of additional considerations that this topic unburies and that arise from this that I definitely want to mention. One is that there is a need for legal protection of DNA integrity while promoting scientific advancements. And the ethical implications of patenting synthetically printed human DNA are huge. There's a lot of people that say there should be no patents on human DNA whatsoever. And then there's another group who say scientists should be free to patent whatever they want, because in doing so, science is propelled forward. And I see a good argument on both sides. Gene patents have a large impact on scientific advancements that should not be unreasonably hindered. That is huge. We have so many things today, from antibiotics to a number of medications to the possibility of having genetically engineered organs that include your own DNA. So many scientific advancements that enhance our lives and our future lives are because of gene patents. So that's important to recognize during this debate. Transgenic organisms are common in research, so this is not new, but the fact that we could print DNA is a big transition because it could open up for more patents than ever anticipated on human DNA. Scientists need clarity and human genes need protection. So I'd like to leave you with this thought, and that is that the power to create is not always the power to destroy or the power to take ownership, for what we create may be something sacred. So thank you so much, and I'd like to now turn it back over to Professor Lucas.
All right, there we go. Thank you so much, Hannah. And as I did in my introduction, her name is Hannah Joy, and you can see the joy that she has for this topic, the passion that she has for protecting the intellectual property rights of those folks who are trying to figure out how to contribute to our society. One of her purposes in life is trying to protect capital investment so that people will continue to explore and to think through these issues. So Hannah, thank you. Outstanding job. I understood most of what you were saying, but I think I would have to really think deeply on those complex topics. So I'm looking at the chat function on the right side of the screen. Keep up your participation. I know that our presenters love to look over there and see the responses by you. I've also asked them to continue to look over there for any of your questions. And so if you have any questions at this point of Anna or of Hannah, please put the questions there. And in the final 15 minutes, they will pick a few of those and spend a little bit of time addressing your questions. But as far as praise goes and how proud we are of them, I don't think there can be enough comments. So great job with that. Keep them coming. And then finally, let's transition to our final third-year presenter of the evening. Like I said, Jillian Engen was there from the very beginning, and she's just steady and constant, always a supporter of this program, always a supporter of her classmates, instantly got the vision of what all of us can do together if we build this honors program. And Jillian's paper is entitled Legislative Prayer and Local Government, an analysis of the Fourth and Sixth Circuit's interpretation of Town of Greece. Jillian, it's all yours. Jillian, how's your technology? Can you hear us? Calling all Jillian Engens in the room. Okay, what is somewhat common and can be anticipated when we move to this new medium is technical difficulty. One of the honors program students from Kentucky wrote to me last night and said that with the tornadoes that came through his neighborhood, it knocked down all the trees, all the poles. They're without internet service and telephone service and electrical service. And those are just some of the challenges that American education, American business, American justice systems are dealing with. And so one last call for Jillian. Okay, so I just got, Jillian is writing to me right now in the chat function, so we're using technology to the best of our ability. We all tested our systems yesterday just to make sure, but that's life in this new frontier. Jillian is saying that her microphone shows it's working. But see if she can try something else. I'll give you just a few more moments, Jillian. I don't want us to miss your presentation.
Professor Lucas, we had to do this for one of the moot court rounds with one of the competitors, and she actually, while still on the screen, called in with her cell phone and spoke through the cell phone, but presented on the screen in case that works.
Thank you. And that's what we talked about yesterday. She always has that ability to use the call-in function. And so, Jillian, you can either keep trying through your computer system or just phone into the number and we'll bring you up by phone. And she wants to assure all of us that she's not trying to get out of this. I tell you, if I were a third year, I probably would want to get out of this, especially following those two. Well, let's do this. Jillian, as soon as you have the capability, either through your mic on your computer or through just dialing in with your phone, we will go directly to you. But how about we take a few questions at this point? And so Hannah or Anna, if there are any questions that you see in the chat function, if you'll take a couple moments to address those. And then as soon as Jillian is ready to go, we'll break to her. But right now, let's do some Q&A.
There you go. I got one question about extradition and whether I thought at all about extraditing the perpetrator to the country in which the crime occurred. And I did briefly do some research on that. It would depend on what country the crime occurs in and what crimes they have on the books, because there are going to be some crimes in the United States that aren't going to easily correlate or have a parallel in the country in which the crime occurred. And so that's the first step you'd have to look at. Is the incident that happened, is there a law in the books that's going to make that a crime, or is it a nation that's not going to recognize that as a crime? In that case, then we do need to prosecute it in the United States. Another thing to take into consideration is that even if it's on the books as a crime, the nation, I guess the host nation, may not choose to prosecute it for a variety of reasons. And that's something to consider, politics or something like that. And so the brief research I did on that area would suggest that ideally, if it's on the books and they will prosecute, then that's your best case scenario, because it's going to be easier to get the victim to testify most likely and get other evidence there. But in situations in which that isn't an option, then that's where kind of my article comes in. But thank you for the question.
I got a question, and I got one from Professor Lucas and then one from Professor Linda Valtson. Professor Linda Valtson says that she's curious about any biblical worldview implications on the issues. She said she's curious about that it could open doors to things that later we wish we may not have opened those doors. I think that is an excellent point. If we were to grant patents on certain genes that are human genes that are 3D printed, for example, we're also interested in becoming smarter as law school students. So what if there was a gene that you could order for your child that would give them enhanced intelligence? And parents are already doing this where they can pick certain eye colors. The Wall Street Journal was reporting about how certain parents are ordering children with certain genes that they want. So what if there was this gene that if your child had it inserted, they would be a super smart child? Well, that does bring a lot of ethical issues, because what that means is that you are purchasing something that is of nature and that is of sacred value. And of course, there are so many worldview implications, because ultimately God is the creator, and also you're excluding that from the rest of humanity and not giving the rest of humanity for that gene. You can kind of see the implications of people who are pure evolutionists with no divine design or with no God in their life. They think that we are enhancing our species, and why not move forward, and why not let the survivalist prevail? So there are a lot of ethical issues.
Okay, thank you, Anna, and thank you, Hannah. Jillian, are you on the call? I see a phone number in the list of guests. Perhaps you're trying to call in right now. Jillian, going once. Okay, Anna and Hannah, there are a few more questions in there. I see another one about morality. If anyone at this point has any questions, we'll go right to the Q&A portion. We've already started it. And again, if Jillian gets back on the line and has the ability to present her paper, we certainly will get her in the queue. But any other questions, Hannah, Anna, any questions that come up, feel free to jump in and address those.
Can you hear me?
Oh, ladies and gentlemen, Jillian Engen is in the room.
Okay, I'm doing this on my phones. We'll see. Hello, can you see me?
Yes, we can see you and hear you.
So I guess you missed my whole intro. I just thank you, Professor Lucas, for putting this on and putting so much effort into this and the honors program. And thank you, Anna and Hannah, for those great presentations. My sister just texted me to put headphones in, so I'm gonna grab them. Just give me 1 second. I'm so sorry.
Well, Jillian, thank you for trying to make it work. You're almost like a wartime correspondent here.
Well, coming to you live, Lynchburg, Virginia.
All right, you're ready. It's all yours.
Okay. Okay, so now that we have that figured out, my topic for my article was legislative prayer, and specifically legislator-led prayer in local government. The interplay of religion and government is so varied and complex. It's so interesting. People have no issue when a government official offers thoughts and prayers in a tweet to victims of disaster, whether it's human or nature caused, or when President George W. Bush gave a prayer 5 days after 9/11. The constitutionality of his ability as sitting president to say a prayer that was broadcast nationally was not challenged. So on one hand, there are times where prayers are welcomed by the public from their public officials. But when do government prayers cross the line? When do government prayers violate the Constitution? I remember when I was growing up in my church, there was a guy who worked with the church youth group. And he also volunteered to go into the school cafeteria and eat with the kids during some days of the week. It was a ministry for him, and it was really great that these kids had someone there for them. And one day, he was sitting with kids from the youth group, and they were talking about Sunday night, and there was a boy at the table who didn't go to church. And he went home and told his mom about how this man had invited him to youth group, and that was it. This man was essentially kicked out of the cafeteria for a simple statement intended to be inclusive. And I remember thinking, is that right? Is it fair? Would every religion be afforded the same treatment? What if instead of a church group, it had been a club that met to discuss the Big Bang? How can we distinguish between different beliefs without discriminating? And last year, I had the opportunity through Law Review to write an article about a topic that interested me. And so I was, researching, trying to figure out what I wanted to write on, which was a really challenging process. And then I found this circuit split between the Fourth and the Sixth Circuits that hadn't been resolved yet by the Supreme Court, and that dealt with the constitutionality of prayer by officials in local government meetings. And I thought, well, I'm a pastor's kid. I graduated from Liberty University, and I'm going to Liberty University School of Law. Surely I can write about prayer. And so I went in with kind of a firm mentality of course, prayer should be constitutional. But I'm not sure that I hold to that mentality quite so firmly now. First, I'm going to give a brief overview of the history of legislative prayer. Second, I'm going to discuss the two key Supreme Court cases in this area. And then third, I'm going to go over the two cases that make up the circuit split. Finally, I'm going to discuss solutions. For the history of legislative prayer, we can look back as far as the Continental Congress in 1774, when the Continental Congress began opening meetings with prayer led by a paid chaplain.
And the first Congress of the United States, once formed, put together committees, one for the House and one for the Senate, to consider election of chaplains. Then within a month of forming the committee, each body had elected a chaplain. And then later the same year, they established a salary for the chaplain right before they finalized the language for the Bill of Rights, including the First Amendment. And the decision to commence legislative sessions with prayer was not without opposition. For example, John Jay and John Rutledge felt that delegates with their various beliefs would not be able to join together in prayer. However, this was refuted by others, such as Samuel Adams, who said that, quote, he was no bigot and could hear a prayer from a gentleman of piety and virtue who was at the same time a friend to his country. And so the practice of opening legislative bodies with prayer was established. And then another matter of concern in this area is the history of religious freedom. Europe in particular, at the time that America was formed, had gone through many religious wars, including the Crusades and the Wars of the Reformation, among others, and lots of conflict between Catholic and Protestant groups. The Pilgrims who came to America on the Mayflower were fleeing religious persecution. The Founding Fathers focused on religious freedom as one of the key rights in the Bill of Rights. They made it the First Amendment to the Constitution, highlighting its importance. And the first clause of the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So we have these two competing ideas, the idea that prayer is an acceptable historical practice, even when the prayer is from a religion not one's own. And then we have the idea that religious freedom is precious and the government should neither infringe upon the people's freedom to practice religion nor establish a state religion. So that leads us to our first key case, which is Marsh versus Chambers. And the Supreme Court decided Marsh v. Chambers in 1983, answering the question of whether a state-paid chaplain opening the Nebraska legislature sessions with prayer constituted a violation of the Establishment Clause. The court affirmed the practice as constitutional, bypassing other established tests for First Amendment violations and establishing what was essentially a new test or a new old test based on the close history of the legislative prayer practice with the First Amendment. The court found that the chaplain's prayers were non-sectarian, were not proselytizing, and even though the chaplain had a long tenure, at this point he had been the chaplain for 16 years running. There was no evidence of an impermissible motive in his continuous reappointment. Then, after Marsh, courts widely interpreted Marsh as requiring non-sectarian prayer, that is, prayer that's not referring to any specific deity or religion, or a prayer to just God in general. However, the Supreme Court overturned that notion in 2014 when it ruled on Town of Greece v. Galloway, which is our second key case in this area. In Town of Greece v. Galloway, the Supreme Court again upheld the practice of legislative prayer, this time in a town board in Greece, New York. So this board would open their meetings with prayer. And to select a prayer giver, a town employee would go through the congregations listed in a directory until they found a minister willing to give the prayer. And eventually they put together a list of board chaplains who had previously given a prayer and who agreed to return. The majority of prayer givers were Christian, although no willing prayer givers were excluded or denied, and no guidance was given as to prayer content. Non-Christian prayer givers included a Jewish layman, a Baha'i chairman, and a Wiccan priestess. And the plaintiffs in this case brought suit alleging an Establishment Clause violation because the prayers given were sectarian. They requested that the board be limited to inclusive and ecumenical prayers that referred only to a generic God, that would not associate the government with any one faith or belief. Then the court, looking at these facts, reasoned that just because prayers are sectarian does not mean that they constitute a violation. The court acknowledged the growing diversity of religion in the United States, but they said that the solution was not censorship of sectarian prayer. Rather, the solution should be the inclusion of ministers of many creeds. The court rejected the idea of government censorship or supervision. The government has no authority to require ministers to set aside their nuanced and deeply personal beliefs for vague and artificial ones. To do so, said the court, would make the First Amendment a rule by the majority. And the court also said that they would not have to look outside their borders. The town had no duty to look outside its borders to make its prayer practice more inclusive. They could just do their best with what they had. However, the court did impose certain limitations on the content of the legislative prayer. The court said that courts should look at the entirety of the circumstances, consider the setting, the audience, and the pattern of prayers over time, and also consider the following. They said that prayers should be solemn and respectful in tone and invite lawmakers to reflect upon shared ideals and common ends before they embark on the fractious business of governing. It has a formal purpose of getting the members of the town board to come together and reflect on what brings them together instead of what sets them apart. Legislative prayer cannot, quote, denigrate non-believers or religious minorities, threaten damnation, or preach conversion. That would be contrary to its purpose. A prayer practice is invalid where it has, quote, been exploited to proselytize or advance any one or to disparage any other faith. And while a few instances of impermissible prayers is not sufficient to show a violation, and a court should not generally dissect individual prayers, if there is a, quote, pattern of impermissible prayers, the court should make a closer analysis. The practice cannot be coercive either, although the justices disagreed on what constitutes coercion. In the setting of a town board meeting where many community members are present, it is easier for the prayer practice to be used as like a litmus test, with those who participate in the prayer shown favor and those who don't by remaining seated when everyone is asked to stand or by not bowing their head, disfavored. If there are reasonable alternatives for those who do not wish to participate, such as arriving late, leaving the room, or sitting instead of standing, then the practice is generally not coercive. And it was under these two cases that the Fourth Circuit decided Lund v. Rowan County, and the Sixth Circuit decided Bournemouth v. County of Jackson. And each circuit court looked at three things to make its decision. They looked at the identity of the prayer givers. They looked at the sectarian, exclusively Christian invocations, because in both towns, the prayers were almost exclusively Christian. And third, they looked at the coercive nature of the prayers. And they were both decided in 2017. In Lund v. Rowan County, 3 citizens of Rowan County, North Carolina, brought suit against the County Board of Commissioners for the prayer practice used to open the bi-monthly board meetings. At the beginning of each meeting, one of the 5 commissioners would give a prayer. They would rotate the prayer opportunity among themselves, and there was no directive as to prayer content, but the practice was limited to the commissioners. And the plaintiffs brought suit because they argued each of the prayers was invariably and unmistakably sectarian in content, because this was brought right before Town of Greece was actually decided. And some of the prayers confessed sin and asked for forgiveness on the community's behalf. And most prayers were sectarian in nature, 97%, in fact, over a 5.5-year period, referred specifically to Jesus or Christ or Savior. So the Fourth Circuit found that the prayer practice was unconstitutional when they looked at the 3 factors. So they first looked at the identity of the prayer givers and emphasized the fact that the prayers were given by the government officials themselves rather than an intermediary. Further, because there was a closed universe of prayer givers, the board was essentially restricting the number of faiths included. This factor was the most important to the court. It really colored the court's interpretation of every other factor, and they looked at every other factor through this lens. So when they moved on to the factor of the fact that the prayers were sectarian and exclusively Christian invocations, not only they found that not only did the board restrict the opportunity to pray to its members, the members also, quote, unceasingly and exclusively invoked Christianity. The court looked at the prayers for over about a 5-year period and found that out of 143 prayers, only 4 were non-sectarian. Further, the court, unsurprisingly, found that the invocations crossed the line and promoted Christianity. There were prayers that the court described as portraying Christianity as the only way to salvation, proclaiming the, quote, spiritual and moral supremacy of Christianity, and urging listeners to embrace Christianity. So then the court looked at the coercive nature of the practice. The court looked at invitations given by commissioners to the attendees. So the commissioners would stand up at the front and ask the audience to rise. And they found that the commissioners' prayers were not internally focused, but sought audience involvement. Even though the prayers in Town of Greece had similar requests to those of Rowan County, the Town of Greece prayers, the prayers in Town of Greece came from the clergy and not from government officials. And so the court held that that was a major distinction. And because the prayer practice took place in the intimate setting of a municipal board meeting, this heightened the possibility and the opportunity for coercion. So considering these factors together, with each factor looked at in light of the other factors, the court held the practice unconstitutional. So in direct opposition to this decision is Bournemouth v. County of Jackson. So the facts are very similar. A citizen of Jackson County, Michigan, brought suit against the County Board of Commissioners for the prayer practice used to open its monthly board meetings. At the beginning of each meeting, one of the 9 commissioners would give a prayer. The commissioners rotated the prayer opportunity among them, and there was no directive as to prayer content, but the practice was limited to the commissioners. So does this sound familiar? The plaintiff brought suit because he claimed the prayer practice violated the Establishment Clause. However, the Sixth Circuit, unlike the Fourth Circuit, interestingly drew attention to some qualities of the plaintiff in this case. They said he was a self-professed pagan and animist who appeared to be particularly litigious, and he had sued because he had sued multiple county officials for what he claimed was religious discrimination. So then the court, after drawing that interesting anecdote, looking at the identity of the plaintiff, went into discussing the facts of the case. So looking at the identity of the prayer givers, the court found that the identity of the prayer giver was not restricted by Marsh or Town of Greece, and that legislator-led prayer is a historical tradition similar to chaplain-led prayer. And this practice has continued all over the country to this day, drawing a direct opposition to the holding from Lund. And the court found that if the identity of the prayer giver were the prevailing factor, then it would lead to absurd results because the same prayer could be found both constitutional and unconstitutional, depending on whether it was given by a chaplain on the one hand or by an elected official on the other. So, and this is key, looking at the other factors, the court did not view those factors through the lens of legislators giving the prayer. And so looking at the sectarian Christian nature of the prayers, the court found that although the prayers were frequently sectarian, they did not constitute a pattern of denigration or proselytization, which was forbidden by Town of Greece. Further, the policy was facially neutral. So the commissioners could be of different faiths or of no faith. They could be elected and the prayer practice would not be changed. Further, they said that there is no requirement for religious heterogeneity because the policy was one of non-discrimination. So it was facially neutral. And there was no need for the commissioners to balance their prayer practice between different religions. So looking at the coercive nature of the prayers, the court held that the practice was not coercive because citizens could refrain from participating by leaving the room, arriving late, protesting the practice afterward. Even if they just sat there in silence, any, quote, quiet acquiescence should not, in light of our traditions, be interpreted as an agreement with the words or ideas expressed. The commissioner's directives to please stand and pray or some variety thereof was not coercive. Even if it was not given by a minister, these are commonplace reflexive requests. The court said finally that offense is not equivalent to coercion. So just because the plaintiff was offended by the practice, that did not mean that the prayer practice was coercive. So after analyzing these two cases, my proposed solution that I put in my paper was that a 3-part test should be used. The Fourth Circuit did not separate out the factors identified, instead viewing each factor through the lens of the other factors. Going forward, courts should implement a more structured test. So first, the court should determine whether the practice falls within the tradition of prayer intended by the framers of the Constitution, looking at the identity of the prayer giver and the nature of the prayer. Second, the court should determine whether the practice is coercive, looking through the lens of a reasonable observer, considering the setting and audience of the prayer, and keeping in mind the tradition of legislative prayer. Third, the court should examine the prayer practice holistically under the totality of the circumstances. There is the place to look at all of the factors together. And you can find that if the factors separately are permissible, if the whole amount, as a whole, they amount to proselytizing or coercion, then the practice should be declared impermissible. And that was the solution that I put together. But even then, and more so now, almost a year and a half later, I don't know that I had or have a solution. I thought it would be easy to go through the analysis and just conclude that obviously the Sixth Circuit got it right and the Fourth Circuit got it wrong. But while I do think that the Sixth Circuit's analysis was more closely tied to the Supreme Court's analysis, I can't say where the line should be drawn. One problem that I had was, how can a court determine whether a prayer practice is being exploited and used to proselytize? For example, the court in Lund v. Rowan County pointed to this prayer as preaching conversion. Quote, "I pray that they may be one in you, that the world may believe that you sent Jesus to save us from our sins. May we hunger and thirst for righteousness, be made perfect in holiness, and be preserved whole and entire, spirit, soul, and body, irreproachable at the coming of our Lord Jesus Christ." End quote. That prayer is from John 17, the prayer of Jesus. Would most Christians view this as proselytizing? Further, is there a prayer that is not in some way proselytizing? Doesn't every prayer imply to some extent that the worldview held by the prayer giver is, in that person's opinion, the best worldview? Even those who say all religions are equally valid are implying that those who view their religion as exclusively correct are wrong. So part of me also is cynical. Did the courts really make a decision based on just the facts of the case, or was it the facts of the case plus the identity of the plaintiffs? As I said, the court in Bournemouth v. County of Jackson took the time to identify the plaintiff as a self-professed pagan and animist who felt that Christianity had destroyed his religion. He was litigious. He caused disruption at board meetings. He didn't really seem like a very pleasant person. So is that a factor that the courts implicitly considered? And then, can we judge between prayers? When I have kids, will I be offended if I take them to a county board meeting and the opening prayer is by a Wiccan priestess? If Christianity were a minority religion, like it was in ancient Rome, could I go and listen to a prayer to Jupiter for justice, or to Mars, the Roman god of war? Or would I want to change the practice? Would I be like the plaintiffs in these cases, bringing a suit to end a practice? I really don't know. And I think this is something that needs careful thought and analysis. And we can't come into it with a position, like in a position of moral superiority, or like I came into it feeling like I was being personally attacked as a Christian for wanting to have prayer in the public sphere. So we need to take care that we don't steamroll minority religions, because we are not going for rule by the majority. We also don't want to water down religions to make them more, quote, palatable to non-adherents. Above all, the solution should be fair. It should not be determined based on who is in charge. And the solution is not to ban religion from the public sphere, which would impermissibly elevate the secular religion. But as Anna rightly said, this is an evolving discussion that doesn't necessarily have one right answer. So that is what I went through in getting to this presentation, is a lot of late nights sitting up at night just thinking about, what is the right answer? What are we going to do about this? Where do we go from here? So thank you.
Okay, Jillian, thank you very much. Thank you for enduring and overcoming. And if the three speakers could get your video going, And so each of our speakers could come up, Anna as well. Well, we're at that time of the night where we've run a little bit over, and so we're not going to take more of your time. I know that you have many questions. We all do. Every right answer in the legal framework starts with the right question, and so I always look for people who have the right questions rather than all the answers. And so our student scholars tonight helped all of us start to think through some pretty important issues. And so first, I want to thank our 3 student scholars. I want to thank you for being brave. I want to thank you for being service-minded, committed to excellence. You've started a tradition tonight. So we're going to build a really great honors program, and none of us are going to do it by ourselves. We're going to do it one brick at a time, and you all have placed very important foundational bricks into that program. For the 1Ls and 2Ls that are listening to this, get your bricks ready. We want you to put as many bricks in this wall as possible. You don't have to build the whole pillar. You just have to start to build brick by brick. Thank you to everyone who came out tonight. The 3 students are honored. I'm honored that you would spend tonight during this really busy and tumultuous season to be with us. It's the inaugural Honors Program Student Scholarship Presentation. 40, 50, 100 years from now, hopefully this will continue, and we were all part of it. So as we come to the close, what I encourage everyone to do is, before you leave, drop off a comment for our panelists, or come to the front of the room and say something to them. But thank you so much. Thank you to the panelists. The 4 of us, the 3 students and I, will stay in this room until it's empty. So if you have any comments or you want to come to the front of the room, please do so. But ladies, thank you very much.